Well, good morning, everyone. Roland, thank you for that very kind introduction. Codex is a very special place to me and to all of us. It's the place where technology and law come together. I've learned a lot in the 11 years of FutureLaw. At the early days of FutureLaw, I was transitioning from my life in big law to my life in the rest of the world. And Codex has been extraordinarily helpful to me in learning about technology and the ways in which it can advance the way legal service is delivered, but also in learning about the rest of the legal ecosystem. I'm going to talk today about access to justice. I knew very little about this subject from the perspective of a big law firm, and a lot of what I've learned because of my activities here at Codex. So I'm very grateful. I am honored to be able to make this keynote and talk to you about this important subject, which is access to justice. Everyone in this room knows something about it. Some of you know way more than I do about it. My real purpose today is to make some observations you may not have had before, make sure that we all are focused on just how grave the crisis is, but then to implore all of us to engage in the process of changing the rules that govern legal service, because it is such an important impediment to the progress we need to make. Before I start, I want to find the clicker, and then I want to reference an essay I wrote. This was a wild experience for me. I hadn't written anything that even looked like an academic paper since I was in law school myself. I have much greater respect for all of you who are academics than I did before I did this. You can access my essay. It's in the link to the agenda. But I want to mention it here at the beginning because it deals in much more detail with the subjects I'm going to talk about. It has all the citations, 138 footnotes to support what I say. But it also has a companion. When Yale asked me, this is the Yale Law Journal, when they asked me to write my essay, and I said yes, they said, hey, how about we get someone else to write the opposite point of view? You are going to write about how the rules need to be changed. We'll get someone to write who will write about why they shouldn't be changed. Sounded good to me, and so they recruited a man named Stephen Younger, who is a leader in the movement. I hope we get some laughs, because I've got some other things coming up. But a lot of you know Stephen Younger. So Stephen Younger, former president of the New York Bar Association, wrote an essay in which he staked out the position that the rules need not be changed. They are justified, each and every one of them, that I think should be changed, he thinks should remain. So for any of you who haven't thought a lot about this, you can read those two essays and get a feel for the arguments on both sides. But today, Mr. Younger is going to help me, because when we come to the discussion about why do we have each of the rules I think we should modify or repeal, I don't have to spend a lot of time on what the argument is on the other side. I'm just going to quote Mr. Younger on what the rationale is for the other side. So let me start by talking about the access to justice crisis. In our world today, in most public discussions, we orient to exaggerating things. But to call our situation in America a crisis in access to justice is not an exaggeration. It starts with this. A fundamental part of the American ethos is justice for all. Every American is proud of that facet and others about who we are as a country. In one of the first issues identified by the founders when they wrote the Constitution of the United States was achieving justice. Every school child in America recites the Pledge of Allegiance in the morning, pledging her allegiance, and at the end of her pledge, she says, "and justice for all." In the world of the 21st century, especially in a country like the United States, if you don't have access to legal service, you don't have justice. Our law, there's so much more law. It's so much more complicated. The courts are complicated. The courts are opaque. If you don't have someone to help you navigate our system, you don't have justice. But the facts are that most people don't have access to legal service. It's a fact. So let me show you the details, many of which I'm sure all of you know. Every year, 100 million or more people have a significant challenge with a civil legal issue. And what I'm talking about today is civil law. Criminal law proceeds differently. Civil law. 100 million of our 330 or however many million we have, people have a real issue with civil law. 80% of the people that need a lawyer don't have one. 80%. In my essay, I cite a study where it's worse. It's 84%. But it's somewhere in the order of 80, might be 70. It's probably 80. Don't have access to a lawyer. Those are individuals. Businesses, it's 60%. 60%. In a world where law is so much a part of your business, 60% of the businesses can't get a lawyer. But here's the statistic that I think is most stunning. Well, that's not it. In state courts around the country, 76% of all cases has at least one party, sometimes more, without a lawyer. We've gotten all the way to court. We're in a court proceeding, and somebody's there with no lawyer at all 3 times out of 4. In some kinds of cases, it's 90%. This is rule of law, United States of America, and 3/4 of the cases have somebody who's not represented. And then when we see our position in the world, this is where we stand. We're 126th out of 139 industrialized countries in the world. We're at the bottom. This country there is no excuse. There is no satisfactory explanation for us as the United States of America to be in this position. This is not a secret. It is not controversial. Even Mr. Younger concedes in his essay, we have an access to justice problem. We just can solve it some other way, which you'll be able to see what he thinks that is. But it's not controversial. This is Justice Gorsuch and former Justice Corliss in the USA Today several years ago, acknowledging that most Americans don't have access to justice. This is not simply statistical. This has real impact on people and their businesses. For individuals, they lose custody of their children. They lose their homes. Their assets are seized. Their wages are seized. They get deported. It is real. This is not just a number. For the businesses, they can't get the licenses they need. They can't get the certificates. They can't get the approvals. They can't enforce their contracts. They can't enter contracts. They are the victims of litigation, even without merit, and they can't defend themselves. It is very real. And as Deborah Rohde and Jason Solomon and Annie Wanless wrote from the Center on the Legal Profession, it has staggering effect. Domestic violence, illness, serious economic hardship among them. This is justice in America. It is not justice for all. So how did we get here? It was not always this way. Jim Sandman cites a study that shows that in the latter part of the 20th century, the final quarter, we still had relatively decent access to justice. This is something that has really gotten worse and worse over the last few decades. There are a lot of reasons we are in this situation. Everyone in the room who pays attention to this knows it's not just a single thing. Part of it is the nature of the individuals and the clients. They're not experts in law. They're not accustomed to law. They don't often know they even have a legal issue when they first have a legal issue. So that's part of the issue. That's part of the problem. Part of the problem is there's so much more law. It's in everything. And there's more litigation. And there's more data making every controversy more complicated. That's part of it. Part of it is the cost of delivering traditional legal service has become so high, largely because it's so dependent on lawyers to do everything, and because it has become so expensive to get a legal education. Other than here at the Leland Stanford Junior University, in most places it's very expensive to get a legal education. All of those things contribute, all of them. But there's one issue. There's one factor that causes this that stands out because it is so obvious, it is so direct, but most importantly, it is fixable. And that is the way the rules that govern legal service in America work. And I use the expression govern legal service because the rules don't just govern the practice of law. When I was in law school and I studied the rules of professional responsibility, this is all about us. This is all about lawyers and the ethical obligations you have and so on. But these rules do much more than regulate how the lawyers practice law. They regulate who can engage in any form of legal service. They regulate how law firms that are authorized to practice law can organize their businesses. They prescribe a business model. And as I'll discuss in detail, they end up creating a model that just doesn't work. One takeaway from the statistics I just shared is that whatever we are doing, it is not working. Nobody intended our justice system to end up not able to serve 80% of our people. Nobody intended or even believes that our justice system doesn't serve 60% of our small businesses. But that's where we have gotten. The model that we now permit, the model that prevails in the United States, does not work. And the rules are a big reason for that by limiting who can participate and prescribing the business model. Now, before I get into the rules, or the fun part of this, let me observe a few context issues. The rules were written for a different time. This is so in lots of areas. One of the things Gillian Hadfield is focused on is that the rules were not written for the day of algorithms and certainly not for generative AI. But the law as a whole. But certainly the rules that govern legal service were written for a different time. Things were simpler. When the bedrock rule that I will talk about this morning was first adopted, most streets in the United States were not paved. In most cities, including the largest ones, horses and buggies were still the order of the day. I looked it up. That's when the bedrock rule was written. We're in a different time. We're not only in a different time in the sense of demand, there's way more need for legal service than there was in the late 19th century, early 20th century. Much more need, and it's much more complicated, but there are many more resources we might deploy. When the rules were written, if you wanted to deliver legal service, well, you had to get a lawyer, and it wasn't that hard. But today, it's more complicated, and there are all of these other resources you might deploy, including other people, but also including technology, process design, all sorts of things. So that's the second thing, the second context point. The third context point is this. The more I have looked at these rules, the more I am struck by this core tenet of the rules. There's a core principle in all of these rules, and that is this. We can divide the human beings in the United States into two categories: lawyers and non-lawyers. Now, when I first encountered the expression non-lawyer, I didn't think much of it. In a law firm, for example, there are human beings, some of whom are lawyers, some of whom are not, 6 to 1, half a dozen of another, just about exactly that ratio. That doesn't seem like such a big deal. When we started to hire real professionals in my law firm to do things that weren't the practice of law, they resented being called non-lawyers. One person said to me, I have never been a non-anything in my life. I'd like to not start here. And I've always thought it was a little dismissive. But it's way worse than that. These rules actually divide the entire population into two categories. One's pretty small. The lawyers in the United States represent 0.4% of the population. The non-lawyers represent 99.6%. In other words, everyone. The rules fundamentally exclude essentially everyone from participating. I'm going to talk about the ways in a moment. Think about that. In what other industry would we exclude everybody? Especially when we're not able to serve the people who need us. Why would we do that? All right, let's look at the rules. There are three basic rules that I think warrant examination, three that I emphasized in my essay to the state bars. Yep. Now, this is no more slides. I don't like slides. By the way, I haven't used slides since I was in my law firm. I came here to talk to you. I used slides this morning only for emphasis. And now I'm done with slides, but thank you for helping. So, rule number one. In every state in the United States, there is a rule that prohibits the unauthorized practice of law. Well, that sounds like a good idea. We shouldn't let people who aren't licensed do this thing that needs licensing. The problem, and by the way, this is a crime. Of the three rules I'm going to talk about, this one could end you in jail. But the problem with the rule is the practice of law is defined so vaguely and expansively that it effectively covers all legal service. If you think, well, I can solve this problem, I'm going to create a business, as some of you are doing. I'm going to create a business that will help these people who don't have access to a lawyer. I'll help them. I can get them the legal service they need. You have to be careful. You might go to jail. And ask people to LegalZoom and all of the litigation they went through over the years with what they have been trying to do. Ask Rocket Lawyer. Ask any of the companies that have tried to do this. It chills the ability of people to get into the game. And it is patently overbroad. In legal service, even in the most sophisticated, most complicated kind of legal question, many of the tasks you need to do don't require a law degree. They're not themselves the practice of law in the conventional sense. Anyone who's ever seen an episode of Perry Mason knows this. How many of you, it's an age test. Perry Mason always got his clients off. Apparently once he didn't. But with one exception, he gets these people accused of murder off, and he has a team of 3 people. His trusty assistant, Della Street, and his private investigator, Paul Drake. I think those 2 people might have been engaged in the unauthorized practice of law. Right? We need to narrow the definition of practice of law. It's one thing to have licensing, and it should be done better than it's done, but it's another to let it be so broad that it chills the participation of everybody. So, in the essay, I propose a way to do it. Isolate those things that do require you to go to law school and pass the bar exam, and those require the license, and let everybody else participate. We need more people, not fewer people, and I would open it up. I would at least tailor it. For years, the FTC and the Justice Department have tried to get the states to tailor this rule without success. Even Justice Gorsuch observes the need to do this in the op-ed. This is not a very hard question. So that's number one. Number two, Rule 5.4 of the model rules, adopted by all the states, prohibits non-lawyers, everyone, from participating in the financial success of a law firm. You can't share in the revenue, can't share in the profits, you can't own the equity. You can't have an equity stake in the law firm if you are not a lawyer. We need to change the model. Having said the model doesn't work, we need a new model. To reach these people who are not being served, to reach these businesses that are not being served, requires something different because we have proven the traditional model doesn't work. So what kind of a model do we need? Well, we need one, for starters, that can reach out to these people who are not normal clients in legal issues, who don't know about this sort of thing, don't know where to go. We need outreach and marketing. We need process design. One of the critical problems here is trying to figure out how do you deliver quality, ethical legal service at a cost that will permit you to have a sustainable level of profit at the end of the day so you have a business that'll work. And of course we need to harness the power of technology. It's not just the power of it, it's the capability of it. And we've seen the most recent huge step forward with generative AI. It won't be alone. It's an example. It can do more and more, and it will be a godsend for this access to justice crisis. But you can't do any of those things with people who don't know about them, and they don't teach this stuff in law school. You do not go to law school to learn how to market. And trust me, after running a law firm for a long time, most lawyers don't know how to do that. But you don't go there for marketing, you don't go there for technology, you don't go there for those things. So in the 21st century, we need to permit a model that has serious people with serious roles in the firms that do know about these things. And that would take us a leap forward. So we need to modify Rule 5.4. So what does Mr. Younger say justifies Rule 5.4 in its prohibition? And he says, in fact, let me read it to you if I can find it quickly. He says, as though, I'll just paraphrase. He says, as though everybody would understand it, they might interfere with the exercise of the lawyer's professional judgment. Right. Now, why would you suspect, let alone believe, that every human being in the United States is going to get into a law firm and start interfering with the professional judgment of lawyers? And there is no evidence. Mr. Younger cites no evidence. There is no evidence in the cases. In one case I cite in the statute, a lawyer tried to argue this, and the judge said that we do have no reason to think that you have any greater moral compass than everybody else. It's fatuous. There is no justification. There's no evidence of harm in more open jurisdictions, which is almost every jurisdiction. There's no evidence of harm from people who are not lawyers being engaged in legal service. This Rule 5.4 needs to be modified, if not repealed. One last fact, Arizona studied this carefully on their way to making their decision. 10 minutes left. In making their decision, and found that the only justification for 5.4 was protecting the economics of lawyers. And the third rule is another facet of 5.4, which prohibits non-lawyers from investing equity capital in law firms. The rationale for that? Well, non-lawyers might persuade the lawyers to prioritize profits. I hoped I'd get a laugh from that one. Lawyers do not need any help prioritizing profits. Mr. Younger apparently does not read the American Lawyer magazine, right? And besides, the evidence goes the other way. If you want to infer something from what happens if you prioritize profits, the answer is pretty good. Because the law firms that are trusted with the most significant, most complicated matters in the United States are represented by the law firms that make the highest profits. The law firms distribute now, the leading law firms, largest law firms, distribute millions of dollars per partner every year. And at the ones that really get the lion's share of the most significant cases, they distribute on the order of $5 million or more dollars per partner per year. They get profits, and they're not snowflakes beside this. I've been a lawyer almost 50 years. And while there are exceptions, lawyers take their ethical responsibilities seriously. And the mere fact that an investor would rather make money or in some situation that wouldn't be right is not going to knock them off their dime. So this prohibition, too, I think, cannot be justified and needs to be repealed. So what do we do about this? Well, the answer is in the hands of the bar associations of the states. That's why I wrote my essay to the bar associations. My objective was to maybe have a little bit of influence over them, to maybe shake it up a little bit. That's why I called it the dereliction of duty. That wasn't polite. But I say in the essay, if you don't seriously reconsider your rules, you are in dereliction of your duty to see to it that the people of your state have access to the legal service they need. You are in dereliction of duty. And we'll see if anything makes any impact. But I think what I'm going to come to at the end of my talk, I think the more all of us do, the more likely we will have an impact. But it's in the hands of the states. 2 states, and only 2, have made it all the way through a process. Many, many states are considering this for obvious reasons, the reasons I'm talking about, but only 2 have gotten to the finish line with meaningful progress, Utah and Arizona, and that proves that it can be done. It also shows how essential it is to have leadership and have vision when you enter the process, and both those states did. So in my essay, I lay out for the states a process to go through to get to an outcome that is principled and worth the time and effort people put into it, which involves taking stock of where your state is in terms of access to justice, re-examining what is your mission. Are you trying to protect the monopoly of lawyers, as some writers have suggested? Or are you trying to enable legal service for everyone in your state? And depending on what you're trying to do, then how do your rules need to read? I don't have a lot of optimism that we're going to get meaningful change in the rules around the country at the moment as we stand here. And that's not because the rules shouldn't be modified. It's not because there's necessarily corruption in the system. It's because whenever the rules are put subject to revision, a fight breaks out. This was something that took me by surprise when I first started to learn about regulatory reform. As soon as there is any movement in a state, advocates for the status quo show up. They may not have been very active in the bar before that, but they get very active when the bar begins to think about this. Now the fight, I say it is a fight, and it is not a fair fight. The people who are harmed in the way that those statistics show are not organized. They are not wealthy. The wealthiest people get access to justice, the very wealthiest. But the people who are harmed are just a disconnected set of most Americans, most small businesses, and so they don't have a lobby to go to bat for them on this issue. They don't. There are people who go to bat for regulatory reform, but it is a small group. And it is a group that consists largely of academics, of people who are true believers, like Jim Sandman we'll hear from this afternoon, Gillian Hadfield, who is both an academic and a true believer. It's a small group. And they are outnumbered, and they are out-muscled, and they are out-lobbied by the people who benefit from the status quo. I sat here once in a conference, Deborah Rohde, Jim Sandman, a number of people talking about this in the early days when I was learning about this, and they were explaining why the rules needed to change. So I raised my hand naively and say, well, why don't they? And there was silence. Mark Chandler was there that evening. There was silence in the room. And finally Deborah said, well, all right, I'll say it. And she spoke this truth. The people who benefit from the status quo don't want it changed. And I'm not accusing them of misbehaving. They have an interest, they have a right. They do. They speak, they act, and they protect the status quo. It works for them. Opening the market might not work for them, and so they oppose it vigorously. When you read Mr. Younger's essay, you will see this in full flower. Mr. Younger explains the lawyers don't want this reform, why these reforms are bad. The lawyers don't want them. And then he proceeds to detail state after state after state, where the state Supreme Court or some other leader in the state bar thought the rules should be reconsidered. A panel was empaneled, a blue ribbon panel empaneled. Ideas were generated. They began to get traction, and then in swooped the lawyers and quash it. And I think I've pretty fairly described what Mr. Younger describes in his essay. He says in his essay that if you are a state that thinks about doing what Mr. Baxter suggests, you better prepare for powerful opposition. And you can only succeed if you can overcome powerful opposition. Jim Sandman has developed some data that I cite in my essay that shows very few lawyers show up at these state bar events. I testified in the California process at one point, expecting I would go and meet the Mr. Youngers, and I didn't. They weren't there that day, nor was much of anybody else there that day. The work of this kind is done I think, largely behind closed doors. But it is very effective. So, this is why I wanted to talk to you about this subject this morning. We need more voices. We need more advocates to enter the discussion. That's why I wrote the essay. I say in my very first footnote, we need more of this. The people in this room all believe in the importance of law. Every single person in this room believes law is important. Every single person in this room is here because, from your perspective, whatever you do, in computer science or in the law, you want to make it work better. Whatever your immediate objective is in your law firm or in your company or in your university, it all goes in the same direction. Let's make this work ever better. We need to be more active in this fight. We have resources. We have connections. All of you are respected for what you have accomplished. We can make a difference. We need to stay current on what the bars of our states are doing. We need to weigh in. We need to communicate directly, whether invited or not. We need to testify if we have a chance, write op-eds, find our way to contribute. Jim Sandman is going to talk at the end of the day about other things that you can do, but let me close with this. If we remain silent, if we don't get involved, then we are complicit, because we are in a position to get involved. We know what the stakes are. We know the unrepresented don't have a voice, and if we remain silent, then we're part of the problem. I implore you all to be active, and thank you for letting me say this morning. So thank you, and I could not agree more. And the reason I didn't say more, first of all, Jim's going to talk in the afternoon, with a very good, a panel, an expert panel. But I want to speak to everybody. So not everybody's going to be willing to do what you just said, and I'm glad you are, and I wish more people would. And you are right as you can be, in my opinion. But I want to talk to everybody. We're all in this, and not all of us will do that. That's the reality, right? But we can all do something, and presently, not many of us are. And you can go write your essay, and maybe nobody will read it, and it doesn't matter. But you can try. You can do something, and that's my point. But your point is exactly right. Thank you for that.
Fortunately, we have to. I want to keep everyone.
You should write checks to the legislators that'll make it happen in each state. That's the reality.
Okay.
So this is just one thought. Each state runs differently. So in the end, the state bars have the ball. They do. In California, we saw, well, you can end run them, right? So, and theoretically, the whole thing is supposed to be controlled by the legislature. If they don't control it, the antitrust rules are going to knock the bars out. So the state legislatures are supposed to be involved. The Supreme Court should be actively involved. That's what happened in Arizona and Utah. So you have to know your state, and you have to work with it, and everyone is going to be different. So you are right about that. And again, I had 30 minutes, and it's a little bit more complicated than the way I presented it. But in the end, the action and the responsibility sits there in that state bar. If the state bar exercises its full muscle, it will get much further. That's what Utah and Arizona showed. Arizona, those aren't like blue states. Those people made big change because they had a vision, they had leadership, they overcame, all sorts of things. Anyway, but you're right.
Okay. All right, Ralph, thank you again, Ralph, for the wonderful. So we'll take